And we go to paragraph 12, Commissioners. In summary, apart from correcting the errors identified above, this affidavit records my response to the Commission's latest notice, confirms that the allegations against me are already before the NPA for a prosecutorial decision, asserts my constitutional and statutory right against self-incrimination. 13, I accordingly place this affidavit before the Commission to preserve my constitutional rights, to avoid any further prejudice arising from parallel prosecutorial processes. In conclusion, paragraph 14, lastly, I see the need to state that prior to my then scheduled appearance on 13 July 2026, I took ill and did not appear before the Commission. I placed before the Commission a medical certificate on which a dim view was taken. I have since approached my doctor for the preparation of what I believe is a medical certificate that would be acceptable to the Commission for its details of what led to me being indisposed. It will, together with this affidavit, be delivered to the lawyers of the Commission. I request that the medical condition I suffered from not be made public. And lastly, should I be required to answer questions flowing from this affidavit and other matters in respect of which it has been determined that I would be of assistance to the Commission, the usual subject to timeous notice and the right to legal representation, Commissioners, I would be willing to make myself available for such.
Thank you. That brings us to the conclusion of your third statement. And once again, to check if there are any additions you'd like to make to that statement.
It was the addition that I made,
that you made
under paragraph 5.
Okay. You say you omitted to, at paragraph 5, you add that you omitted to deal with an exhibit CJC 368. That's the first document in the exhibit file or pack of documents from pages 1 to 133.
That is correct.
Now, I had indicated that after you have addressed your third statement, I will indicate to the Commission where my understanding is your legal representatives, Mr. Bodlani and his team, and I landed on the question of self-incrimination. And I want to test whether the rights you assert at paragraphs 8 and 9 accord with our understanding and our decision. Firstly, our understanding is you are not invoking a blanket ban on dealing with the issues that are reflected in CJC 368, the documents that you say you omitted to deal with, and that you invoke your right against self-incrimination in response to specific questions, not that questions can't be put to you. That is what Advocate Bodlani and I understood to be the correct legal position. I want to understand whether that is your understanding as well. That questions may be put to you, and in response to each question, you then get to decide whether you invoke your right against self-incrimination.
That is correct, because I understood that is the rules under which the Commission does operate, and so there is no blanket, but it is on a question by question.
Okay. Now, because it's you sitting here, you do invoke Section 3, Sub 4 of the Commissions Act. You reference it there, paragraph 8. And that is, I think, in our Act, what secures your right against self-incrimination. I find it interesting that you have a similar provision in the Act, in the NPA Act. And I want to see whether you draw a distinction between your testifying before the Commission and what those whom you engage during course of investigation are expected to do. In this regard, I would like to refer you to Section 28, Sub 8, A and B. And it will be projected soon if you don't have it immediately in front of you.
Of the NPA Act?
Of the NPA Act,
Section 28.
28, Sub 8, A and B. And Section 8A reads, I quote, "The law regarding privilege as applicable to a witness summoned to give evidence in a criminal case in a magistrate's court shall apply in relation to the questioning of a person in terms of subsection 6, provided that such a person shall not be entitled to refuse to answer any question upon the ground that the answer would tend to expose him or her to a criminal charge." Sub B, no evidence regarding any questions and answers contemplated in paragraph A shall be admissible in any criminal proceedings except in criminal proceedings where the person concerned stands trial on a charge contemplated in subsections 10, B or C, or in section 319 sub 3 of the Criminal Procedure Act. So, considering the position you assume in regard to Exhibit 368, do we land at a place where those that IDEC interviews and questions are in a different position to witnesses, including yourself, appearing here today? Because if I understand sub 8, as the persons that you question during course of investigation may not refuse to answer a question upon the ground that the answer would tend to expose him or her to a criminal charge. Do you have a different standard than the one you are seeking to invoke in your protection today?
Sorry, Ms.
Yes,
Sello. Can you please explain to me the comparison, if it is a comparison, that you are making with this section?
The comparison I seek to make is, if I understand the witness code.
Let me perhaps explain.
Yes.
And I'm asking the question because this specifically relates to a witness called before a magistrate's court. Yes.
Yes. Chair, if one has regard to sub B, 8B, it says no evidence regarding any questions and answers contemplated in paragraph A shall be admissible in any criminal proceedings, except in criminal proceedings where the person concerned stands trial on a charge contemplated in sub 10, sub B and C. 10, B and C below provide any person who has been summoned to appear before the ID, and then A is without sufficient cause fails to appear, fails B at his appearance fails to produce a document requested, having been sworn or having made an affirmation, 1, fails to answer fully and to the best of his ability any question lawfully put to him or her. That is the comparison I seek to make, which is what the Commissions Act also provides in respect of witnesses. And my reading of sub 8 together with sub 10 would suggest that the witnesses that are interviewed, and I'm not saying interrogated, interviewed by the investigating director, cannot refuse to answer questions on the basis that they would tend to expose themselves to a criminal charge subsequently. They may not fail to answer any question put to them to the best of their ability. So I read 28 sub 8 to be equivalent to the Commissions Act section 3 sub 4, which means that the rights are the same, but it would appear that those being interviewed by the ID do not have the basis or the scope to refuse to answer questions, notwithstanding the fact that they may incriminate themselves. So I just wanted to understand from the ID whether, is it the same right, or does the Commissions Act afford greater rights than the NPA Act does to those who are summoned by the investigating director to answer questions?
It's for me.
Yes.
Is it 3 sub 4 that applies, or is it section 6? Because my 3 sub 4 deals with witness fees and privilege and other things. But the equivalent of this, I see it in section 6 of the Commissions Act.
And it's because section 6 will cross-refer you to this section 3.4, referencing the privilege applicable to anyone, I think in a match court, if memory serves me well. So they should be read conjunctively to get to a position where a witness may invoke a right against self-incrimination. And we say that that right is protected in terms of section 3.4 read with section 6. We can get to the regulations as well. The regulations, I think regulation 8 expound further on that, but we can't rely on the regulation to interpret the act.
Can I
Yes,
add
Commissioner.
something to this, which is turning out to be a complicated issue, and without being technical about it? The provisions speak of a privilege.
Yes.
And privilege is different from the shield of self-incrimination. It's two different concepts. Privilege, as I understand it, is about your discussion with your attorney, with your lawyer. So I'm under no obligation, or our 3.4, when I say our, I mean Commissions Act, gives a witness protection not to reveal matters that are the subject of discussion with their legal representative. I didn't understand that we are in that territory with the third statement. I thought the third statement speaks to self-incrimination, which is, as we know, a completely different concept.
Yes, Commissioner, or at first blush, we get where we are thanks to the Constitutional Court matter, Secretary Judicial Commission of Inquiry into Allegations of State Capture versus Zuma, 2021, bracket 5 SA1CC. That is the case that determined that the rights in section 3, sub 4 and 6 include the right not to self-incriminate. And the Constitutional Court considered, and it was argued before it by some or other amicus curiae, that it doesn't include the right of against self-incrimination, but the Constitutional Court determined that it does. They have a right not to self-incriminate.
Thank you.
And part of the basis for that is that the Constitutional Court held in the same matter, I submit correctly so, that the rights afforded in terms of section 35(3), sub 3 of the Constitution do not apply to a person who's not an accused person. So she can invoke section 35 of the Constitution, but she may invoke 3 sub 4. This is what lands us here. We may not get a resolution. I raise it to make the point that the rights the witness seems to assert would appear, on my reading, to be greater than the rights afforded persons that are interviewed by the investigating directorate, and wonder whether my interpretation is correct, and should that be the case, is it not the same right? And why it is the NPA Act seems to be so stringent when it comes to the invocation of that right. I pose this question specifically to this particular witness because she happens to be a lawyer and advocate over 30 years, and they handle these matters. I take it on the regular. I thought she might be able to shed some light, but if she can't, then it would be a matter for consideration by the Commission as we go forward. If she can't give a response now, I'm happy to leave it there, Chair.
Please restate your question, perhaps, for the benefit of Advocate Johnson.
Advocate Johnson raises in the third statement the right not to self-incriminate. And we have, I think, gotten to a point where at least she and I agree that she can invoke that right in response to specific questions as we go along. Now, I consider section 28, sub 8A and B read with sub 10, that the right she seeks to assert is not the right afforded any person interrogated by the investigating director or the directorate. And I wanted to understand if my understanding is correct or whether there is the same right. My reading of section 28 sub 8 read with sub 5 would seem to suggest that it's not. Which would mean the witnesses that they, no, not witnesses, the persons that they question cannot refuse to answer on the grounds that they would expose themselves to criminal charge. And it is precisely that ground she seeks to invoke going forward in refusing to respond to questions. It need not detain us. It might be a matter that Advocate Johnson may consider overnight. I just want to know where we land on this right against self-incrimination.
Ms. Sello, what I want,
Yes.
may I suggest that if we leave it at Advocate Johnson to consider this overnight, you may also want to have regard to Regulation 8.2, which speaks to the treatment of self-incriminating answers before the Commission. This is the regulations of the Commission. So consider that as well.
Of this commission.
Yes.
Thank you, Commissioner Baloy.
Oh, sorry, it now works.
Yes, yes.
I was thinking that maybe it's not working because we are now where we are. No, that's fine. I think the issue I wanted to raise has since been taken care of. Now this matter, it being one that is going to be considered by Ms. Johnson overnight. Our concern was of what consequence really is it. Ms. Johnson is before the Commission, the rules of the Commission apply. She's not before IDEC, she's not before the ID. It may very well be that the Act accords her more rights than she otherwise would have, or vice versa. But the rules of the Commissions are the rules of the Commission are the rules of the Commission, and that's what applies. To the extent that the ID is before you today, what operates here and what regulates the Commission trumps over whatever else she might be entitled to elsewhere. She is not elsewhere now, she is before you. But we'll consider the matter overnight.
And as Ms. Sello indicated, there's agreement that Ms. or rather Advocate Johnson's responses will be on a question-by-question basis, and that it's not blanket.
Indeed.
Yeah.
Indeed, Chair.
Indeed, that's the agreement, Chair.
Yes, thank you.
My apologies. I confirm that, Chair. I opened that. I'd assumed, and I hope rightly so, although I think I didn't give warning, that the engagement, the probing of Advocate Johnson's testimony that she spent the greater part of the day putting before the commissioners has ended and the probing had started.
Yes,
so
yes.
I start at section 28. to see if we can have an engagement that could better inform the commissioners about how these matters are dealt with. I do not for a second am confused about where Advocate Johnson is today. She's before the commission, it's section 3 sub 4. She heads a directorate that seemed to have a similar provision in the act, applicable act, and I just wanted to understand how it applies to others and whether there is a difference. It's the sole purpose for which I referenced 28 sub 8. Thank you, Chair. But as we have agreed, she'll consider it overnight and we will see where we land tomorrow when we resume.
Yes. May I just start with this question? I hope it won't
Indeed,
disrupt
Chair.
your probing.
Indeed.
Advocate Johnson, Colonel Padiachi said that he has never been furnished with copies of affidavits that support Section 27 referrals. He testified that all